Hello everyone, my name is Manvi and today I am going to tell you about malice. Malice is a term with many meanings. Firstly, it is often used to mean spitefully or with ill will. Like other motives, malice in this sense is invariably irrelevant in the law of torts and therefore is not essential to the maintenance of an action for tort. Malice has second meaning. In the legal sense, malice means the intentional commission of an act with an improper motive. It is not confined to the intention of doing an injury to any particular person, but extends to an evil design, a corrupt and a wicked notion against someone at the time of committing the crime. As said by the Salmon, it is the act and not the motive for the act that must be regarded. If the act, apart from the motive, gives rise merely to damage with legal injury, the motive, however reprehensible it may be, will not supplement that element. Now let's see an illustration. If A, intended to poison B, conceals a quantity of poison in an apple and puts it in the way of B and C, against whom he had no ill will, and who, on the contrary, was his friend, happened to eat it and die, A will be guilty of murdering C with malice aforethought. The legal term malice is described as the state of mind that is concomitant with the intentional doing of a wrongful act without any justification or explanation. The term malice is concerned with the intent behind the commission of wrongful conduct of an offense. Now let's see what is the meaning of malicious. Malicious is the adjective of the word malice, which means the desire to harm others. In criminal law, description of malice varies somewhat, but in general, malice isn't as simple as dislike or hate. As you see in the example, a common definition provides that a person acts with malice by intentionally committing a wrongful act without a reasonable excuse. A person shows malice in this context by acting deliberately with a calm mind or with a plan, or committing a purposeful and cruel act without any or without great provocation. Now let's see the types of the malice. Malice is express or implied. It is expressed when the party evinces intention to commit the crime as to kill a man, for example, modern dueling. It is implied when an officer of justice is killed in the discharge of his duty or when death occurs in the prosecution of some unlawful design. It is general rule that when a man commits an act unaccompanied by any circumstance justifying its commission, the law presumes he has acted advisedly and with an intent to produce the consequences which have ensued. Now, malice is further divided into malice in facts, malice in law. Malice in legal sense includes absence of legal justification or valid excuse or recognized mitigation and presence of actual intent to cause a harm that resulted from the act or presence of wanton and willful doing of act with the knowledge and awareness that such harm may be the result. Now let's see what is the meaning of malice in fact. Malice in fact pertains to those conduct or acts which are committed with a sense of hostility or animosity or had a backdrop of ill motive, but the act committed itself are illegal. Malice in fact is also known as actual malice or express malice. When a defendant acts wrongfully with a feeling of spite or ill will, it is said to be done maliciously. Motive means the eventual reason for the conduct. Motive is different from intention, which relates to the wrongful conduct itself. Now let's see some of the related case laws. First is Bradford Corporation versus Pickle. In this case, it was held that if an act is a lawful one, it cannot be rendered as illegal, how severe the animosity may be. He further observed that ill motive or malice intention has very little significance in such cases. Now, in the other case of Vishnu Vasudeva versus THS Pierce, the court declared that the legality of the act has to be taken into consideration. If the act is lawful, the motive behind the commission of the act has the least significance. Now let's proceed towards malice in law. Malice in law refers to the conduct which is done intentionally without any sufficient or cause or valid justification. Malice in law is often called as implied malice. Any wrongful act done with intention is known as malice in law. It doesn't justify any act done with evil or improper motive. Now let's see some of the related case laws. First is Milia versus Niet. In this, the court observed that the term malice in law is associated with disinterested malevolence. The term malice in law has been very well described in the case of Shearer versus Shields. A person inflicting injuries upon other in the contravention with the law cannot take the defense that he did so with an innocent mind. Now let's see the difference between malice in facts and malice in laws. Malice in facts. When an act is done with ill motive towards an individual, then it is called malice in fact or express malice. Whereas when an act is done wrongfully and without reasonable and probable cause, it is malice in law or implied malice. In malice in law, the act done must be wrongful or legal right must be violated. In malice in fact, there must be ill will or any vindictive motive of the defendant against the plaintiff. Whereas in malice in law, there must be concurrence of mind with a wrongful act done by the defendant without just cause or excuse. In malice in fact, motive is a main ingredient, and on the other hand, knowledge is a main ingredient upon malice in law. Hope you have liked the video. Thank you.